So after opening up to stakeholders a little bit in the first roundtable, the second roundtable will take us back to more familiar grounds, the shareholder-manager relationship, which is at the epicenter of company law, the heart of corporate governance. Its raison d'être, if I may provocatively say so. So to explore the important, some have said, seismic evolution of this relationship and understand the new dynamics at work, we are fortunate enough to have with us today international experts and involved actors in corporate governance, starting with Paola Perotti, CEO of at Go Investment Partners, a fund mainly invested in Japan, so we'll have the Japanese perspective. Angus, Director, Risk Compliance at TCI, and a colleague of mine, Alessio Pacces, who is a professor of law and finance, a discipline that doesn't exist in France, unfortunately, at Amsterdam Law School and Business School, and author of numerous books and articles on corporate governance. So thank you very much to all three of you for being with us this morning. As for the structure of this roundtable, we all agree to touch upon three different topics. First one is the recent evolution of the general relationship between shareholders and managers. Second one is the specific development of shareholder activism. And finally, the legal obstacles to shareholder engagement and cooperation. And since I've been recently bumped up from speaker to moderator, but as to keep my role as a speaker, I will try to handle both jobs. I will, as agreed, introduce all topics and then turn to our panelists. So before focusing on activism, it's important to look at the tremendous global landscape change that has taken place over the last decades. I'm referring here to the institutionalization of listed companies' share ownership that has happened worldwide. It's important because the connection is often made between the rise of institutional investors and the rise of shareholder activism. Let's look at the data. In the US, institutional investors are said to hold 73% of the capital of the top 100 listed companies. The figure is 66% for the UK, 30% for France and Germany. And more stock are held by a handful of institutional investors. BlackRock, Vanguard, State Street manage over 90% of all assets under management in passive funds, and together constitute the largest owner in 90% of the first 500 listed companies in the US. So the US is no longer a model of dispersed ownership. Yesterday, I wonder if you saw that, the OECD has published its long-awaited report on shareholder ownership in the world. It's called Owners of the World's Listed Companies. And the report said that in the world we have 41,000 listed companies, which represent a combined value of more than $80 trillion, the equivalent of the global GDP. Half of this combined value is held by institutional investors. In half of listed companies, the three largest shareholders hold 50% of the capital. So the Burl and means separation of ownership and control seems to be fading away. But what's important is to underline the fact that this ownership concentration does not in itself lead to shareholder engagement, I mean meaningful engagement, and shareholder control. So let's start with a simple question. What are the reasons for this development, and what are the implications? So maybe, Alessio, you would like to start.
Yes, does that work? Well, first of all, thank you very much for having me here. It's a great pleasure to see such an interesting and exciting debate at the intersection between law and economics, which those of you who know me has been a professional commitment of my entire life. So reasons and implications. there are probably many reasons why institutional ownership has risen so much in the last few decades. But I think one that can't be denied is demography. So when I want to motivate my students to study corporate governance, I just tell them, look, all of us have shares in the biggest companies in the world, which matter a lot in shaping the world we're going to live in. And all of us have shares, and that applies to all of us here too, because there are institutional owners that are managing our savings. And that's a fact. Now, consequences. This is more so taking as a given that the savings of all people, pretty much all people in the world, are in the hands of institutional investors. What that implication of corporate governance, and namely for the decision making of companies that accounts for so much of the global wealth, as Alain just said. So actually have a big, probably huge impact on the world we're going to live in. This ownership matters a lot because ownership implies voting rights, control rights. The question whether they are used or not used, or how they're used, is, I think, the subject matter of this panel. But most importantly is there is most likely a responsibility coming with this large ownership in the key companies in the world, the largest companies in the world. I think a big question that is not answered yet is how the large institutional investors are carrying out this responsibility, and also what it means. Because I don't think even the largest investors, BlackRock, Vanguard, that have been mentioned here, and perhaps are represented in this room, have asked their own investors, so the people on whose behalf they are managing their funds, what they want. And there is a big debate, at least in academia, on what shareholders, indirect shareholders want, and how institutional investors managing these funds are interpreting these preferences. This goes under the label agency cost of agency capitalism. So in a sense, institutional investors' concentration seems to reduce the agency cost of managing companies, but at the same time, institutional investors are agents of others, are our agent. And I'm not sure, we academics are not sure that institutional investors know how to interpret our preferences regarding how to govern companies.
Sure. Thank you. Thank you, Alessio, for such an interesting take on this problem. If I go back to the original question, so why do we have so much money in the hands of few? I think we need to go back to, first of all, the privatization of the retirement industry. So there is more and more people who need to save for their own old age, and the consequence need to provide low-cost products for those people. When we think of of active managers, and we say, why are they not out there like Elliot doing activism? I'm just going to give you a practical take from 30 years in the industry. Imagine you are an active manager. So you're not an activist where you have lots of money and very few companies. You are not a passive investor. You are a good, honest fund manager looking after 100 companies in your portfolio. Every quarter, you get interim reports. You need to update your model. You need to go and see whether your conviction is more or less. 100 companies, 2 hours, that takes 6 weeks of your time. Add in, admin, holidays. There is very little time for those active investors to actually have time to formulate the type of activist thesis that takes months and months of work. So that's all I wanted to say on this point.
Thank you. Angus?
Yes, good afternoon, and lovely to be on this esteemed panel, and with all you, this lovely audience, thank you. Yes, the move to more the shareholding being institutionalized, that's, in many ways it's actually a democratization of shareholding, because traditionally, back 2-3 generations ago, those shareholdings were held by a financial elite. And as Paola said, it's the move towards the more people having to do savings, and the move away from individual shareholding and towards more mutual funds and the like products. It's moved therefore into institutional shareholding. Yes, it's very difficult for them to be actively, meaningfully engaged when they are holding across the whole index or across just the broad spectrum of stocks. And their influence is therefore going to be adjusted by the actions of perhaps the activist investor who might spark some interest. So that's why they will feed off other people. But I think that this may very well change. We've heard a bit about the whole ESG process, and I think that the younger generation are now much more interested in what their fund managers, what they're actually doing with what the companies that they're invested in are actually doing with that money. And I think that will lead either to perhaps more individual shareholding again, or just a multiplicity of funds that have particular aims to satisfy individual desires and needs.
Thank you. So the rise in institutional ownership raises questions about how these investors carry out their corporate governance functions, and prompted a few regulatory initiatives aiming at increasing their involvement and their engagement. We in Europe have the Shareholder Rights Directive, as you know. But my question is, do you think this is a good public policy to try to force institutional investors to engage if their business model is not doesn't limit their capacity, I would say, and ability to engage? So, or does that create some, unintended or perverse effects? So maybe Alessio.
Yes, I think Paola just made a very important point. That in order to screen a company and make an informed judgment whether the company is managed properly or adequately, or however you kind of judgment you want to make, it takes a lot of time. And an investor that has 1,000 portfolio companies just doesn't have the staff to conduct this business. So particularly those funds that are mainly indexed don't have the resources to do that, and more importantly, as Alain just said, that's not their business model. The reason why you index is because you want to provide a low-cost vehicle for savings to be put forward to the retirement age or stuff like that, right? So no, the answer is definitely no. The legislator cannot impose an engagement, let alone a special kind of engagement, because I think what you're referring to is the Shareholder Rights Directive number 2. This just came into force. That reflects very strong views of the European Union, what kind of engagement they want. No, that cannot be done by legislation. And one little note to conclude on this. The Shareholder Rights Directive actually curbs a mechanism that we know exists. It's not the only possible one, but we know it exists, that relies on active and activists teaming up with passive investors, namely hedge fund activism, like we heard before. And by imposing rules, mandatory rules on the identification of shareholder, indirectly, the Shareholder Rights Directive, the new Shareholder Rights Directive, curbs hedge fund activism, and therefore reduces the possibility to have an active engagement. You may say that this is not the kind of engagement the European Union wants, but again, this is not something that can be decided by legislator without looking at the business models. You want to add something?
Thank you. This is a really interesting point, and I'm surprised, and I learned last night that in France, the directive MiFID II request for investors to engage with the companies in which they invested is not seen as mandatory as we have chosen to interpret it in the UK, and let alone Japan, where we have a completely different set of rules. Alain, I hope that I don't sound controversial, but in many ways, I think forcing investors to engage makes them focus on it. Because remember, we are under lots of pressure, and Angus can tell you better than me, fees only go down, and to have good governance specialists costs money. So, unless we have to do it, we will not do it, because, But what perhaps could happen, and I build back, and this goes back to a point made earlier by Alessio, is that, collaboration, you said this is all about collaboration, and while an active investor can never be like the is unlikely to be the main architect of change as such, because they don't have the time or the resources, they may be able to support thesis put forward by other investors. So unless there is a pressure to be seen as active, probably people will do nothing. And you cannot afford to do nothing when 50% of the market is in passive index. It's not me saying it. This is Larry Fink in his BlackRock, in his letter in 2018. Doing nothing is not an option.
I've not got a lot to add to that. I think that there is a likelihood that all institutional investors will try to do more than they're doing currently, but it can only ever be at the edges for the reasons that we've set out already. And I think there is a danger of, particularly on the sort of the ESG side of it, which is where they will probably concentrate because of the angle of the SRD, that it will be really just window dressing for the matter, rather than anything substantive. So I don't see at the moment that's sort of a massive point. But I'd actually quite like to just pick up something from the previous panel, where talking about identification of shareholders, and was this easier or less easy? But in France, in particular, companies have the right in their articles of imposing much lower limits than the statutory ones, and many of them do indeed have 0.5% and above, which we tend to spend quite a lot of our time making shareholder disclosures under the articles or under requests from companies to provide information. So I'm not really sure how in France anyone can claim that it's difficult to know for a company to know who their shareholders are. It is quite difficult to know who the other shareholders are, though.
Yeah, at least they know the meaningful shareholders. Yeah, right. So I'm somewhat uncomfortable calling these investors passive investors. The Americans would say they are not passive; they're reticent. They are somewhat passive investors, but not always passive owners. So I think there seems to be a continuum of shareholder behaviors from completely passivity to public activism, with complex relationships among all actors. So let's now turn to shareholder activism. Activism, as we have seen, is at all-time high. Again, let's look at the data. In the US, more than 100 hedge funds currently engage in frequent activism, and over 3 others have launched activist campaigns in recent years. Assets under management by activist hedge funds have increased substantially by more than tenfold between 2002 to 2018, now representing $250 billion, which is really moderate compared to the largest asset managers. In the EU, with 58 campaigns in 2018, activist funds are now part, undeniably, of the stock market landscape. In France, we've had 40 French groups targeted. I won't say the name. let's look at the contributing factors of this development. We can think of a series of ones. The weakening of traditional control structures of listed companies, the increased weight of foreign shareholders, the internationalization of corporate boards, harmonization of corporate governance, being more standardized, more understandable for foreign active shareholders, and the saturation of activist domestic markets for funds that are mainly Anglo-Saxon, as Activist Insight has showed us. So the question is, how big is shareholder activism in your respective country or your respective hunting grounds, if it's not your country? So, Alessio?
Well, I'll start with a non-answer. I don't think this is the right question to ask, because as I've argued in my articles, it's very difficult to estimate the impact of activism from the activities that you observe. So wherever the activism has a bite, it achieves much more without being triggered. And that's certainly the case in the United States, and possibly in other countries. So now coming to the question that I received, because I want to be disciplined, the simple answer in the Netherlands is certainly the overt activism is not big. There are very few cases. And the reason is the case law, and particularly the special court in the Netherlands that adjudicates matter of engagement and takeovers, called the Price Chamber, and is subject to the Supreme Court, and particularly the Supreme Court has have a very negative stance against hedge fund activism, to the point they stated a principle that is kind of matching the structure of Dutch corporate law, that shareholders do not have any say on strategy. Shareholders cannot ask the board to change the strategy they have set. And this has been applied. One of the latest cases in activism engagement from Elliott was the Akzo Nobel case, and they lost 2 court battles. So for all intents and purposes, this engagement didn't succeed because the court didn't support it. We don't see a lot of activism, but I want to make again a note on the basis of what I said before, and that I think reflects also the Akzo Nobel case. It's not clearly clear that Elliott and in general activism do not have an impact, because indeed Akzo Nobel did something after winning the battle. They divest some line of business, they did something, they also changed something in the board, they appointed some people that Elliott wanted to be appointed to the board. So it's not impactless, even when it appears to be a failure. And there is a lot more going on by companies that know they can be engaged, and therefore they act in anticipation of engagement.
I can only talk about Japan, which is where we focused. And I heard from Yuri Strata that Japan is a hotbed of activism. Who would have thought that all this is happening now? And you know, he's right. You may not be familiar with Japan, but you may all have read on the papers about the fights at Lixil or at Uniso. Right now, we don't know whether Uniso is going to be bought by BlackRock, it's going to be bought by Fortress, it's going to be bought by no one. So it's all very exciting. But what you don't see, what is fascinating that Yuri recognizes that the number of active Elliott-like campaigns are up, but what you fail to perhaps know is that the majority of domestic investors carry out what we call quiet activism, and there's been quite a lot of it. In November, on the 6th of November, at Waseda University, they publish an article on work done on our firm about whether quiet activism has added alpha, and the answer is that from let's wait until the study is published, but preliminary findings find that perhaps a less confrontational type of activism works better in Japan. The last point I wanted to make in Japan, and I could talk forever, as Japan has been my life for many years, is that you may or may not be aware that the largest pension fund of Japan, GPIF, is now cannot invest directly. So they invest via asset managers. They have a 100 years investment horizon. I was in Tokyo in July and I heard Hiro Mizuno speak, he's the CIO, and said, what is long term? Is it 3 years, 5 years? For me, it's 100 years. I'm looking at the pensions of the employers of Japan, employees of Japan now, and their children, their grandchildren. When you look at long term as 100 years, then ESG is not a nice to have. It's not something that we can do it or pretend to do it. Greenwashing, as Angus said, is essential. And he has actually reflected this in the way that he remunerates his managers. So yes, I think activism is healthy in Japan, both in the public deals that you see and make the headlines, but almost much more important, it is internalized, and I think you will see quite a lot of developments, good developments coming out of Japan.
Yes, I mean, to put it really into context, there's very little activism anywhere, really, because it's only a few companies here or there every year. So in the structure of each nation's stock market, it is pretty marginal. But and my knowledge, I guess, is not so much of the UK, because although we are a UK fund manager, our investments are global, and most of our campaigns have been global. And we resist. We don't usually succeed, but we resist the tag of activist because we see ourselves just as an engaged investor. We have very few holdings in our fund. We talked here about the institutional managers having all these assets in different companies. Normally, we would have a maximum of about 20, 25 holdings in the fund, and of that, only 10 would be meaningful positions. So they're large positions, yes. But it does mean it's manageable. It means that we can have our analysts actually spending a lot of time on each of those companies and getting to understand them really well. And from the moment we start building up a position, that dialogue starts, and it will go on for as long as we have the holding, whether we're in agreement with them or not. And hopefully we will take them with us, and we will all be talking about the same sorts of things in the same sort of ways and the same sort of timeframes. We are seen in some quarters as that evil activist, has been said in the past. But there was, at one point when we were having arguments with Deutsche Börse in Germany, we were making investments in Australia with an IPO there, where the press in Australia was saying, isn't it wonderful, we've actually got someone coming onto the shareholder register who cares about the company they're investing in and will actually hold the management to account. So perceptions can be different in Europe from elsewhere, and not necessarily all that helpful.
Thank you. Let's now turn to the utility function of shareholder activism. Activist shareholder seems to do what passive or reticent large institutional shareholders cannot do or would not do. They are less into what some call plain vanilla corporate governance or governance activism, and more about performance activism, and more focused on industries and strategies. And some say that they help create some new collaborative model with its advantages and its risks, because at the end of the day, the activists has to come up with convincing plans to the managers or to other shareholders. And that's what I was saying about the correlation between the rise of institutional shareholders and shareholder activists, because it's much easier for shareholder activists to talk with a handful of institutional investors than a million of them. So maybe Alessio, you would start with how you see the functions of activism in the landscape and the dynamics between activists, managers, and institutional shareholders.
Thank you. So let me start from commenting a little bit one of the things you mentioned. I'm relatively skeptical that this collaboration that can be triggered by the typical business model of an activist for the following reason. The way I see the activist engagement follows a business model. It's a different business model than the model we talked about. And it's a business model that relies on the appreciation of the toehold that an activist purchases before the market knows and learns that there will be engagement, because at that moment it's close to impossible to make money on the stake of the activist engagement. So that's a special business model that is aimed at making, with a kind of horizon that varies. I mean, it's not as short as the standard rhetoric says, but it's not 100 years long either. But it's like that's a goal. That's a business model. You got to make money on that stake. So because that's your motivation. That's the way I see hedge fund activism. I'm not making any judgment. It's very good to keep companies going well. The vast majority probably of companies going well. So you need to persuade, and as an activist, you need to persuade either the managers, so that's the right way to go in order to have a better management of the company, or larger institutional owners. That's the case. And in the second case, I mean, so assume that manager is not cooperating. Then you need to convince exactly those owners that have another business model. So actually, they don't have any time, resources, or interest or incentive to do what an activist has done, so screening a strategy in order to make money on that stake, because they are focused. They have 10 holdings, whereas BlackRock has 1,000, right? So, but the one with 10 holdings has to convince BlackRock to vote for them, because if it doesn't, the campaign would fail. So that's why I don't think this model leads by itself to a cooperative, to more cooperation between shareholders and manager. This cooperation, if it happens, is forced, because managers will cooperate when they realize they're going to lose a battle, okay? But it's confrontational, it's not cooperational. That doesn't imply that there are similar models emerging right now that are more cooperational. And there is, I want to make an example, it was not mentioned, but it is in the literature and it is in the news. The Norwegian fund, the Norwegian Wealth Fund. The Norwegian Wealth Fund is mainly indexed, but also, you know, what we think about the index fund has to be looked at more carefully, and I want to do that in my research myself. So the Norwegian fund can twist the way they track their index, and they can make very strong announcement what they want their portfolio companies to do, otherwise they drop them. And apparently, there is recent research that they've done this credibly. By talking with the managers and persuading them to pursue certain things that they like, ACGs mainly, but also other things. And those who didn't oblige were dropped from the portfolio. And I think that's kind of a way, makes more sense as a cooperative engagement, whereas hedge fund activism, the way I see it, is more confrontational.
Okay. You ask, Alain, what model can be had of cooperation amongst investors. The question for Japan is a bit opaque. While in 2017 the government announced plans which would allow a modicum of collaboration, the reality is that it is really difficult to have the kind of frank discussions between shareholders that you would have, say, for example, in the UK, in the Investors Forum. That is dangerous ground, because you could very easily fall into acting in concert category. And in 2018, 5 large passive funds in Japan started a new initiative, which is called the Institutional Investor Collective Engagement Forum. And they work together on matters which are of a more general nature. So, for example, the first letter they sent to companies was about disclosure of material information. So right now in Japan, that kind of cooperation is not available. And it is, I think it is an obstacle. I mean, I'm not sure, I mean, sometimes companies, and here I'm not talking about Japan, I'm talking about generally, I've been engaging with companies for a very long time. Sometimes management will tell you, look, you have this agenda and investor Y has a different agenda. What do I do? And, they have a point, because in reality, you really need to find a model that works for all. And I don't think we have an answer yet. I have this little idea that perhaps there could be a meeting of, that perhaps as part of the audit committee, there could be a different type of shareholder meeting where people can put forward to the auditors the concerns they have about the company, and that could provide a mutual forum. But I need to flesh it out a bit. But that's what I don't have an answer, a proper answer for that yet, Alain. I'm sorry.
Okay. So obviously we've talked about this. You want to? So sorry.
I'll make it brief then. I mean, clearly, I believe that the TCI model must be the perfect one to follow. But it is that case of slow, long engagement. It's a case of coming into the company with developed ideas. We also tend to invest in the similar types of businesses, so we can use the experiences we've developed from one company across the board to others, and that can be it means that we're less likely to have that confrontation early on.
So as we've seen this morning, the rise of shareholder activists has raised a lot of concerns from a public policy standpoint. Must we, should we, can we regulate shareholder activism? In fact, measuring the costs and benefits of shareholder activism is extremely difficult. It often looks like an entrepreneurial conflict, and we are wondering whether it's a good idea for the lawmakers to take sides, either activists or managers, or leave it to the company and the shareholders of the company globally. So we mentioned that in France we have no less than 4 working groups currently working on shareholder activism. And I'm a member of one of them, actually. We are finalizing our report, the Club des Juristes report. But interestingly, because I cannot talk too much about the content of the report, it's confidential. But what struck me for the 4 different groups is that the groups were created in some kind of anti-activist atmosphere. And during the course of the hearings, of the studies, etc., I think the conclusions and the recommendations of the different working groups will be very, very soft, emphasizing on transparency, trying to identify asymmetries between corporates and activists, maybe give some more capacity of quick intervention to the regulator. But that would be about it. So there won't be major legal changes in the report. Question for you: is there any regulatory changes or proposal for changes in your countries about shareholder activism? Yes, Alessio?
Yes, there is one. But before I get there, I want to say something. First of all, you honored me very much by referring to the entrepreneurship conflict, which has been my take on activism, and I'm very grateful you do that. And I want to say something. I mean, probably that wasn't clear what I said before. I don't think there's a way to decide whether a specific company should be managed for the short term or for the long term at any point in time. So the legislator cannot do that for two reasons. First of all, long term is in the eye of the beholder. We heard it from Paola. And financial market cannot process information that goes 100 years. They simply can't. They're not equipped to do that. It's not, financial market will log great things, but not create value things in 100 years down the road. They can't do that. So, but look, 100 years is a possible definition of long term. Second, even if we had a definition, we could agree in this room, what is the definition, which is daunting. There's no way to decide, as from an entrepreneurship perspective, that a single company, we can name any, should be managed for the long horizon or for the short horizon. Because of that, I think the company should decide themselves whether or not they want to be exposed to activism and to other form of, let's say, dialogue or confrontation with external shareholders that want to have a say on how the company should be managed. This has not been the stance of governments on both sides of the Atlantic. And in the Netherlands, coming to the question I was asked, there is a proposal, there is a legislative proposal that is quite an advanced stage to give the incumbent boards, whether it's dual, as normal, or single, to give some course thinking time. This thinking time is called Bedenktijd, is in the proposal of 250 days. So whatever challenging proposal you received from an engaging shareholders, the board has the right to freeze it for this number of days before this can be voted on. It is currently, it's already there, it's the corporate governance code, but formally that's not binding, although it's like, I think it has 95 or 98% of compliance rate. It's 180, so if it would move to the legislative level and become 250. Now, question, this is part of a discussion that we had last night. These are measures that are kind of in DNA of the Dutch legislator. They wanted to do that for takeovers. And I think it makes kind of sense because it's harsh on a takeover bidder. I'm not sure it's so harsh on an activist. And anyway, my position on that is that the government shouldn't impose that. Perhaps consider giving options to the companies to choose barriers to activism as barriers to takeovers.
Thank you, Alessio. Overall, the trend in Japan is towards, better relationship, more protection of shareholders, better corporate governance. So the trend is up. With one exception that we don't quite figure out yet. A few days ago, the government announced changes to the Foreign Exchange and Foreign Trade Act. So just like in many other countries, Japan has a system that protects sensitive industries. We have it in France too. And if you want to own more than 10% of that company, you need to file. There's been a very sudden, by Japanese standards, change, so that there is a proposal, and it may be influenced by the US, we don't know yet. There is a proposal to decrease the approval threshold from 10% to 1%. Now, so the approval process is quite cumbersome, so that's quite hard. And you say, well, Paola, why does this affect investors? Well, because the government has said, yes, we are making these changes, but we will have exemptions for what they call portfolio investors. So that probably would technically mean most of us, except that we are not quite clear yet whether those portfolio investors start asking for increased dividends, cash buybacks, changes management, whether all of a sudden they stop being portfolio investors and become other investors, and then they have to seek approval once they get 1%. So we don't know what's happening. We're all confused, and we're waiting for some some new information, some better understanding of what Japan wants to do. And it's not just me, it's like a lot of us are a little bit confused. But obviously, people are thinking that this could be a measure to stop activism, because if you are going to be captured by the rules, and you need to get approval. If you own 1% of the company, you want to make any changes, that will delay your ability to influence the company somewhat.
Mm-hmm. And there's no current proposals in the UK for anything. I think we've yet to see the impact that the Shareholder Rights Directive would have. That may have some implications for the way activism is created. But I guess for the last whatever number of years, the UK regulator has not been a rule maker, it's been a rule taker. And suggestions that may change.
Thank you. So our final part for our discussion focus on legal barriers to corporate shareholder engagement and cooperation. Two legal barriers are often mentioned as impediments to the cooperation and engagement of activists. One is market abuses, and the other one is concerted action. Both notions are accused of being used as anti-activist legal weapons. Frédéric Pelletier is not here. I should not use the word weapon, but let's say tool, just to not upset him. But of course, this accusation is unsurprising when it comes from activists themselves. But trying to look at the legal situation objectively, it's difficult not to take the point that the extent and vagueness of both notions, market abuse and concerted action, may worry shareholders who have legitimately opted for an active strategy. Let's start with market abuse. And that's why I'm here, actually. I was invited to give you some input about the use of market abuse against shareholder activists. So I'll take 3 minutes just to share with you some views on this particular topic. I've just finished a paper on the connection between market abuse and shareholder activism. Especially, I tried to compare American and European law on insider trading. And what struck me is the deliberate political choice that we made in Europe to define such criminal offenses that are critical for all market players in a vague and extensive way without providing adequate level of legal certainty to market players in order to avoid inhibiting some useful behavior on the market. In a nutshell, the US insider trading prohibition is based on the violation of a fiduciary duty, either towards the counterparties of the insider or the source of its information. So it's therefore pretty well defined and limited in scope. In the EU, on the contrary, the offense is defined as the mere undue use of inside information by anyone under any circumstances. So it's therefore based not on a contractual exception on the freedom to trade shares on the market, but on a public policy principle of equal access of investors to information. And the definition of both elements of the offense, inside information and undue use of this inside information, lack clarity, to say the least. So consequently, regarding not insiders, managers, directors, but outsiders, like activists, well, it seems very difficult to conceive in the US fiduciary system where the inside information has to be wrongfully obtained by the outsider. In the European system, which welcomes what I call the paradoxical figure of the self-insider, holder of proprietary inside information based on his personal intention, the mere knowledge by the outsider of the public statement of its own intention, of its own engagement in the listed companies, can be construed under MAR as being inside information, which therefore prohibits the outsider, the activist, from using it before publication. And similarly, while there's nothing in the US that would prevent an activist from communicating his engagement to other activists or to other shareholders, such transaction, such communication would be considered as violating MAR prohibition of communication of inside information. So we see to what extent a strictly egalitarian conception of insider trading could end up with practically prohibiting the current practice of public shareholder activism, either long activism or short activism. So the risk is that such broad interpretations of MAR prohibitions can be instrumentalized to lock activists in what I call a legal trap of being accused of either market manipulation if what they say on the market is misleading or can be construed as misleading, or of insider trading when it's not misleading, when it's actually the intentions. And more recently, activists faced another legal risk of violating MAR provisions. The MAR provisions on investment recommendations, given the extensive nature of this concept under MAR, which includes, I quote, any opinion expressed on the current or future price or value of a financial instrument, or information merely suggesting, this is the actual word of MAR, suggesting an investment recommendation regardless of the legal status of the producer of this suggestion or recommendation. So this is the actual current state of European law that I, as you understood, that I criticize in my paper. So I would like to have your take on the use of market abuse against shareholder activists. Is there any example in your respective country? Or if not, what's your general opinion about it?
Okay, just follow the order. But I mean, unfortunately, the answer as far as the Netherlands is concerned is no. So it's uninteresting from that respect, because in the Netherlands, the courts, as I said before, has a very negative stance towards hedge fund activism. So it's not even an issue. You don't need more than that. That being said, I want to say two things. First of all, the article by Alain is great. So I would recommend everyone to read it because I would actually use it in my own security regulation course for a simple reason. I mean, we both naturally follow this approach that to describe the market abuse regulation approach to insider trading, market manipulation. So what I tell my students is, the whole game in Europe is to get into an exception, because anybody, including yourself, you trade on what you know. Otherwise, you're an insider, right? That's the way it's constructed. Now, unfortunately, there is an exception, for instance, for takeover bidders. So if you're a takeover bidder, you wanna make a nostalgia bid on a company, you wouldn't be covered because there's an exception. There is no exception for hedge fund activism. So what I would say in this case, given what we've been discussing so far, there should be an exception in the market abuse regulation for this kind of engagement. That's the only way to make it work. Alternatively, if you side with those, I mean, on the other side of the Atlantic, the regime is completely different. So hedge funds, activist hedge funds wouldn't be caught by insider trading at all. But there are scholars, like Chekhov, for instance, that have been arguing that should be the case. So it depends really on your take on activism, what you want to do. If, like, I'm kind of neutral. I think that activism can be very good for some companies, and some companies may prefer to be away from activism. Then it should be possible. I certainly do not support a regulatory stance against, or courts against, activists, like seems to be the case here in Europe. So there should be a reform.
Thank you. you, Alessio. I'd like to join Alessio in recommending the paper by Alain on market abuse. And I love the history at the beginning, the notes about the first prosecution was in 1942 in the United States. So I learned a lot reading Alain's paper. On market abuse within Japan, I know that it's getting late and perhaps you don't want me to go into much legal detail. I'll tell you my wish. And this is not really, it's not really the fault of Japanese companies, but you know, Japanese companies produce their accounts and information in Japanese, and not many of us speak Japanese. So there is always a time lag between the information as is made available to domestic fund managers and the information that is made available to other investors who don't have either the Japanese language competence or Japanese colleagues. So if I could express a wish, you know, I would wish for a more timely translation of those documents. I mean, as I said, it's not really Japan's fault that they have such a difficult language, but it is an obstacle to ensure that everyone has access to the same information at roughly the same time.
I think in the UK, most of the prosecutions on market abuse have been against individuals for insider trading rather than against the activist community. So I think we've been reasonably exempt from that, much as I'm sure they would love to find good examples to prosecute. But I mean, in our position, we tend to build up our position to where we want it to be before we start taking any action. Mm-hmm. So we would not ever be trading on inside information. Mm-hmm. Except, of course, we will, under things like in France, the law for orange, our position might increase with the double shareholding votes, but we haven't actually made an investment decision to increase it.
So our last point before the Q&A session is concerted action. And here again, the problem comes the fact that despite the important risks involved in this characterization as acting in concert, the notion is rather vague and possibly intrusive. So ESMA in 2013 published a public statement with a wide list of activities that investors may wish to engage in without fearing this legal characterization. So the question is now, should we extend this legal certainty effort outside the battle of corporate control, because the ESMA statement just relates to the takeover bid directive concept of concerted action. So what, in your experience, is it a legal obstacle for cooperating with among investors, this notion? I'm sure it is, but how do you deal with this issue?
I would pass this one.
I may have just to repeat myself. Right now, we can really, collaboration is not something we can do. So in our fund, we only have, so just like in Angus fund, but much smaller, we only have 12 positions. We don't cooperate with anyone. I mean, we wouldn't do it because, one of all, because legally, as I said earlier, this is a very gray area in Japan. And second, because as philosophy for our investment style, we believe that change can only really happen if both parties can engage in a safe space. And if I go to talk to a CEO of a company to discuss a thesis and we share thoughts, and the following day, you know, that information perhaps gets known to other people, then you're no longer able to have a real conversation. It's only when you really talk to each other and in a safe, secure space that change can really happen. So that's why we don't do it.
Yeah, again, briefly, it's we would tend not to want to be in concert with somebody else. We would tend to be willing to share our views and to let the recipient of those opinions go away and do what they want to do with the decision they reach. We have, in the past, felt that with the discussions we had with another fund could potentially have mounted to acting in concert, so we disclosed that fact and revised all our shareholding disclosures. But within days, if not, certainly yes, within days, we really decided that we didn't have any sort of plan between us, so we weren't acting in concert. But how do you then cease to be acting in concert when you never quite were in the first place? So I think you do need to have some real trigger to disclose that you are now acting in concert. But of course, a regulator will see that in hindsight and may take a different view.